and welcome to our training on referrals to care. Let's go ahead and take a look at our agenda. We have several different sections. In the first one, we'll have an introduction, just describe the difference between a referral and a petition, and what that could look like. And then we're going to talk about two types of referral that are defined by statute. So those are facility referrals and then court referrals, and talk about how those might flow. And then counties also have the option to build in a process to accept referrals from other community partners and other types of referrals. So we'll talk about what that could look like and provide some guidance. So as far as learning objectives, the goal is that by the end of the session, you'll better be able to explain the difference between petitions and referrals, understand components of referrals for care respondents, identify the differences in referral processes for various system and community partners, and then describe how counties may process and respond to care referrals. Our presentation today, I'll be joined by my two colleagues, Deborah Rose with HMA and Leela Kapoor, who's the mental health law lead, and will walk us through some of those referral pathways and help us understand the differences in what that might look like. So I'll turn the time over to them to get started.
Thanks, Patricia. It's good to be here with you today. Let's just dive into the material. Here we have what the care process workflow looks like. You've seen this before, so I'm not going to go through it in detail today. You can click on links or you can go to our website for the actual document or for additional information. What I want you to know here is that the process can begin a couple different ways. It's a civil court process, as you know. It is not a criminal court process. Here, care can begin when a petitioner initiates a case, which may also be prompted by a referral, but essentially it begins when somebody's been identified and is being considered for care. So we're going to talk through, moving forward, all of the instances which a referral can be made in this training. Next slide. Thank you. So let's begin the discussion today by identifying the differences and similarities between referrals and petitions. A petition is where an eligible petitioner or an organization files with the court directly a care petition. The CARE Act, which we'll talk about in a moment, a little bit more specifies who can file these petitions. In some cases, it may be appropriate or it may be a consideration for that petitioner to make a referral instead. We'll talk about that. But it's also important to note that when an outside entity, when an individual or an organization files directly with the court, the County Behavioral Health steps in at the initial appearance and take over the role of petitioner. So the County Behavioral Health is essentially responsible for processes after that point. The referral, on the other hand, can come from multiple places, and the CARE Act specifies some parameters for who can be making referrals, and that can be a couple of examples, like a court to care or certain facilities to care. With these referrals, County Behavioral Health, or in a case of conservatorship, is required to think about whether the individual is likely to benefit from care and will make a decision to file a petition. We're going to talk about some of these statutory referrals. What we're referring to as statutory referrals because they're specifically written into the care statute later in the presentation. And again, we'll give some examples and instances where a referral might go directly to the care court from another court like AOT or LPS, and the individual may be deemed, this will be deemed a petition for the purposes of care. Couple ideas is that County Behavioral Health can establish a referral process, not only for those that are determined by statute, but for those that may be elective. So nothing precludes a county from taking a referral for, let's say, a family member for consideration. And then important to keep in mind that referrals for care can sometimes expedite the process or can facilitate access to services. That might mean more timely access to services because somebody has been flagged early on and brought to the attention of County Behavioral Health. It may mean improved outcomes because there could be earlier intervention and it could be done in the right context of where the person is at the time. It certainly can mean a more streamlined process for all parties that are involved. So let's take a look at who the eligible petitioners may be. And if you, again, like more information, this is all available on our website. I'm not going to go through this entire list. There are a number of individuals that can be petitioners. It's pretty broad. In some cases, people can come together to identify who the best petitioner might be. People who are adults over the age of 18, it could be a roommate, a family member, domestic partner, a parent. It could also be by system partners. And so that includes hospitals, agencies where an individual is being treated, a licensed behavioral health professional, protective services, tribal courts, among others. In many instances on this list, you'll see that there's a little asterisk, and that denotes where a designee can also be appointed for one of these entities. So a broad range of people who can be petitioners, and we are considering these petitioners and these referral sources as we go through the training. Let's take a look at the next slide, please. And again, here is where we talk about statutory referrals. And here we're using that term to mean that these referral sources are specifically identified in the care statute. And so when we think about county agencies like behavioral health or even public guardian or public conservatorship, those agencies are required to accept certain referrals from certain courts or from certain facilities, and namely AOT, LPS, we're going to talk about that. But this type of referral, these statutory referrals, are again governed by these notes that are in the statute, and they're really set to make sure that certain criteria and procedures are to put into place. So we're going to walk through all of these in detail, and I think this is probably the right time to jump into some of the specifics about statutory referrals. Again, making a quick note here that although other referrals, like family members or significant others, domestic partners, I should say, can make referrals to county behavioral health. Other system partners like hospitals or whatnot can choose to make a referral rather than filing a petition directly. They're not specifically identified in the care statute, so there's some flexibility and county discretion on how those referrals can be managed. And so we'll talk about that in a lot of detail as we move forward. And with that, I'm going to ask Leela and take a moment to bring in my colleague and say, Leela, when you think about the differences between a petition and a referral, what comes to mind? What would you ask people to note?
So first of all, hi, Deborah. So as you pointed out, a petition is the document that's required to be filed with the court to initiate a care process. And you've already pointed out that by the statute, there's a long list of individuals or entities who are allowed to file those petitions. A referral, again, as you pointed out, is a person or an organization who's providing information to another party. And most often, this is going to be the county behavioral health department that's going to receive these referrals. In some cases, as you've mentioned, it might be the conservator or a proposed conservator in an LPS proceeding. But those individuals are going to receive information regarding somebody who the referring party thinks may be eligible for care. And there are statutory referrals that we've discussed, as well as non-statutory referrals, those that are informal, that aren't required or authorized by the statute. But county behavioral health is really encouraged to consider those referrals and establish pathways that those referrals can be received by behavioral health. So while we are going to be focusing on the statutory referrals, we want you to keep in mind that there are other opportunities for referrals for collaboration, which are extremely important in engaging individuals in care. We're also going to talk a little bit about court-to-court referrals. And in some instances, and we'll get into detail a little bit later, but in some instances, certain courts can make a referral directly to the care court. And if that referral is sufficient enough, contains enough information, the care court can consider it to be a petition and not require a separate petition be filed. So that's a little bit of an anomaly out there that we'll talk about in detail as we go forward.
Thanks, Leela. And I am glad to see you today as well. So we've set the stage pretty well now for some of these ideas of referrals and petitions. And you said something which is important, and I want to highlight the idea of formal versus informal. And when we say formal referrals, we're talking about those statutory ones that are in the CARE Act. When we say informal referrals, those are those other ones that aren't specifically addressed, like a family member or a domestic partner or a hospital or provider, let's say. So let's jump into it in a little bit more detail and talk about what it might look like if facilities are making referrals. So one of those statutory referrals are from LPS designated facilities. And that means that these are folks who are specifically working with individuals who are on an involuntary hold for behavioral health. And so some of the things that we'd want to think about are the timings, the timing of the referral. The facility really should be part of the assessment process or the intake process, be considering care and care referral. I should make that referral as early as possible to County BH so that that can be included in discharge planning for the person. County BH then has 14 business days to assess the individual after receiving the referral. It's at that time that they at least identify if the person meets care or is likely to meet care, and if the person might benefit from care. And also want to note that in that process, uh, the facility can't hold somebody just for the purpose of making a care referral or for that determination that they need to treat that individual as they would ordinarily, and they can't just wait for the BH assessment to be completed before they discharge the individual. Also important to note that this referral does not affect the ability of making an AOT referral. So a facility can both refer to care and to AOT. And again, as I mentioned, this really should be part of discharge planning for an overall better outcome. So I think we can go to the next slide, please. And let's talk about who those eligible facilities are. The law does define them. These include facilities that are under WIC 5150. And so again, this is a facility that's providing assessment, evaluation, crisis intervention, and that allows individuals to be held for up to 72 hours. Or designated mental health treatment facilities. These are under Code 508. And these might include facilities that are licensed or certified by the Department of Public Health, and that may be a licensed psych hospital, a psychiatric health facility, or a crisis stabilization unit. So keep in mind that it is not just the facility, it's the individual, and the individual must be under an involuntary hold in one of these facilities to be considered for statutory referral to care. So we've talked about the facilities a bit, and we've talked about who some of the players are. Let's get into some of the specifics around these referrals. Thank you. As I said, facilities can refer to the County Behavioral Health Agency. Important to note here that County BH can be either where the person is currently receiving services, so the county where the involuntary hold is being conducted, or it can be in the county of residence where the individual lives. As part of that referral, it must be made by a licensed behavioral health provider who is either employed or contracted by the facility. And importantly, that this licensed behavioral health provider needs to have specific knowledge about the individual's case. That person needs to be involved in the treatment during the hold. And the professional needs to also essentially state that they believe the individual meets criteria, is likely to meet criteria, and would likely benefit from a care process. And so as part of this referral process, that licensed behavioral health professional or their designee must sign and provide documentation for the referral. So you might ask yourself, well, how are those referrals being made? And so the DHCS has developed a form. I think we could bring it up now to show you what that form might look like. It's part of the BIN 25012. And essentially, this asks facilities to provide information to support a petition along with a copy of the individual's model of care coordination plan. And there are some links in our deck. Again, you can find those live links if you come onto our website, and they're listed below. So a few things about this form. You'll see there's a template that's here. This matches what's currently available online. The form doesn't have to be used. The facility or county BH can come up with another form that matches each of these elements, and in some case can supplant this form. So this can be used, and certainly agencies are encouraged to use the form. However, if the facility or county BH chooses to use their own form, some of the minimum elements need to be included, like the person's name, how to find the person, the designee's name, etc. I'm not going to read all of those elements because you could see them on the form, but the idea is that there should be information that makes it that expedites the process and that makes it easier for county BH to reach out to gather information and to assess that individual. Form also needs to confirm that the licensed behavioral health provider is authorized to make this referral. And again, we've talked about that they have knowledge of the case, have been involved in the case, and believe that that person is likely to benefit from care. As we continue, let's talk about when making a referral, what can be included in that. And certainly there have been questions about information sharing and HIPAA. We're hearing anecdotally that most times information is being shared with an individual's consent. And of course, that's the best opportunity to include individuals in care planning as well as other treatment planning. So you really want to partner with that person to gain their consent. And if consent isn't provided for whatever reason, then we encourage facilities and individuals to reach out to their privacy office or legal counsel to discuss options that can be offered for sharing of information. So you can see more information on the Senate Bill 35, and we've included again some links at the bottom of our screen. I'm going to bring Leela back again, if you're not already here, and then say, Leela, let's take a couple moments. We like to put these ideas into action and think about how they might be used. So what are some of those things that facilities should consider when they're determining whether they should make a referral to care?
Well, clearly, Deborah, they should be looking at the individual from a clinical perspective and determining whether they believe the individual is eligible or potentially eligible for care. So they don't have to have a definitive determination that the individual meets eligibility criteria, but they should have a good faith professional belief that the individual may meet the criteria. They should be considering whether the individual would benefit from the care program. Clearly, that it is a less restrictive alternative to either their current treatment situation or those that might be available to them through other pathways. They want to look to see if the individual is receptive to participating in care. Fundamentally, care is a voluntary program, so it's important that the individual is receptive, or at least it appears that they could be receptive with the right engagement in participating in the care process. And finally, you might want to look at whether or not a referral is the better option. Many of these facilities may have the ability to file a petition themselves without going through a referral process, but they may want to consider a referral because it allows for collaboration with the county behavioral health agency, and it might be a more effective way of getting the individual engaged in services, whether it be through care or through another pathway. So they want to consider what those options look like and what might be best for the individual involved. So I'm going to take the mic away from you, Deborah, and give you a little bit of a rest, and I'm going to move on to court referrals to care. And I'm going to start by talking about court-to-court referrals. These referrals are set forth in the statute, and therefore they are somewhat complex. So I'm going to try to make this as straightforward as possible for all of you. When we talk about court-to-court referrals, we're talking about referrals that are coming out of certain specific courts. Specifically, we're talking about referrals coming out of courts, criminal courts, whether it is a criminal proceeding, whether it's a felony or a misdemeanor, in which the individual has been determined to be incompetent to stand trial. So these are called IST courts, the FIST courts for the felonies and the MIST courts for the misdemeanors. And these courts have a pathway under the CARE Act to make a care referral. And we're going to talk about that pathway in a second. The other court that can also do this is the LPS Conservatorship Court, as well as the AOT Court, the Assisted Outpatient Treatment Courts. They can all make referrals using, again, the statutory formal referrals that are set forth in the CARE statutes. There are a couple ways these referrals can run, and we're going to kind of talk to you through both of the pathways that allow for these referrals. The first is that these courts, these referring courts, can make a referral directly to the CARE court. And at that point, the CARE court will consider the referral. And if the court determines that the petition is sufficient, if it includes enough information for the CARE court to feel that it is sufficient to act as a petition, the CARE court can deem it a petition and accept it as a petition. So what the CARE court is looking for is whether the referral includes all the information that is required to be included in a CARE petition. And what we're really talking about are facts that support CARE eligibility. Is there enough information in that referral for the court to make an initial assessment of whether or not the individual is eligible for CARE? Whether the referral in essence makes a prima facie showing, and again, an initial showing that the individual meets or may meet the CARE eligibility. If the CARE court deems that the referral is sufficient enough to be a petition, then the CARE court is going to, and we can move on to the next slide, please. The CARE court, if the CARE court deems that the referral out of the IST court or the LPS conservatorship court or the AOT court is sufficient to be a petition, the CARE court is going to notify the referring court that it has accepted the referral as a petition, and that petition is going to go through the CARE process in the same way that any other petition was. So the CARE process is initiated at that point, and no additional or separate petition form is required. If the CARE court does not feel that the petition contains enough, that the referral contains enough information to be deemed a petition, the CARE court is going to order the petitioner candidate, I'm going to discuss who that is in just a moment, but the CARE court is going to order the petitioner candidate to investigate the referral and notify the referring court within 14 court days whether they intend to file a petition. So as an example, if a referral is made to the CARE court from an IST court or the AOT court, and the CARE court does not believe the referral is sufficient to be deemed a petition, the CARE court is going to ask or order the county behavioral health director or their designee to investigate the petition and investigate the referral and notify the referring court within 14 court days whether they intend to file a petition. If the referral comes out of the LPS conservatorship court, the CARE court is going to order the conservator or the proposed conservator to do that investigation and notify the referring court of whether or not it intends to file a petition. So that is a pathway by which the IST courts, the LPS conservatorship courts, and the AOT courts can make a referral through the CARE court to determine eligibility of somebody for care. Moving to the next slide, we're going to talk a little bit about another pathway that courts can use to make a referral to care. And again, we're still talking about the IST courts, the LPS courts, and the AOT courts. As we talked about before, they can make a referral to the CARE court. Their other alternative is to make a referral directly to the county. And what this looks like is one of these referring courts refers a individual to the county. If it is an IST or an AOT referral, it's going to go to the county behavioral health agency. And if it's an LPS referral, it's going to go to the conservator or the proposed conservator, who most likely is going to be the public guardian or the public conservator. So if one of the referring courts does not want to or do not believe they have enough information to make a referral directly to the care court, they can still make a referral, but it would go through the county for its investigation and determination of whether a petition should be filed or not. So again, I'm just going to reiterate 2 different pathways for those courts to make a referral to determine eligibility for someone to enter into the care program. I'm going to move on to the next slide. And we're going to spend a little time getting into some of the nitty-gritty around these referrals because they are statutory. They do have certain parameters that have to be met as they're processed through the referral process. So we're going to start with referrals out of the MIS court. Again, these are criminal court proceedings, misdemeanor proceedings where the individual has been determined incompetent to stand trial. And a recent addition to the CARE Act, effective January of 2026, allows for these referrals by missed courts early on in the criminal process. And specifically what it allows for is that at the hearing held after the initial determination of incompetency. So again, very early on in the criminal process. At that hearing, the court can determine whether or not it would like to make a care referral. It can also at the same time make a referral to a diversion program. So you need to keep in mind it's not exclusive. They can be, both of those things can be going on at the same time. But if the court determines that it wants to make a referral to care at that point, the care court will hold a hearing to determine eligibility within 30 court days of the referral. So there is a time frame attached to that. If the hearing is not held by the care court within the 30 court days, an individual in county jail shall be released pending the hearing. So again, important to know that there is a timeline attached. If the individual is accepted into care, the care court shall notify the criminal court and the charges shall be dismissed 6 months after the referral, unless the case is referred back to the criminal court by the care court. So again, there's a time frame attached to when those criminal charges would be dismissed. It is very important to note with this referral being made early on in the criminal process, the referral can only be made if the defendant or their counsel agree to the referral and the court believes that the individual may be eligible for care. So unlike other referrals, a referral made by a MIS court at this early juncture in the criminal process requires the consent of the defendant or their counsel. Also important to note that with this referral, as well as other referrals made out of the MIS court, the county behavioral health and jail medical providers can share confidential medical records and other relevant information associated with the referral, so as to allow the court to determine eligibility. So there's a specific provision that allows for the sharing of that information between county behavioral health and the jail medical providers. Moving to the next slide, we're talking about the other opportunity in a missed proceeding where a referral can be made. So we talked about it being made very early in the process after the initial determination of incompetency. The CARE statutes also allow a court to make a referral, a missed referral to CARE later in the process. And this is when the individual is deemed ineligible or unsuitable for diversion. So the individual may have attempted diversion and not been successful in it, or had been determined unsuitable for diversion for certain reasons. And in those instances, which will usually come later in the process, the missed court can make a referral to CARE. In these instances, the CARE court holds a hearing to determine eligibility within 14 court dates after the date the petition is filed. If the hearing is not held within those 14 court dates, an individual in county jail shall be released pending the hearing. If the individual is accepted into CARE, the CARE court shall notify the criminal court and the charges shall be dismissed 6 months after the referral, unless the case is referred back by the CARE court to the criminal court prior to that time. So again, there's timelines attached to this. Each of these timelines differ a little bit depending upon whether it's missed or FIST or what type of referral it is out of missed. So it's important that you understand that and you read through those timelines and are aware of them if you're handling any of these referrals. I'm going to just spend one slide, which is the next slide, please, on referrals from FIS cases. These are felony incompetent to stand trial cases. So if an individual is found incompetent to stand trial in certain felony proceedings, and they are deemed ineligible or unsuitable for diversion, the criminal court may refer the individual to care. So this is an opportunity, but it only becomes an opportunity after the person has been deemed ineligible or unsuitable for a diversion program. In these instances, a hearing is to be held to determine care eligibility within 14 court days from the date of the petition is filed with the care court. If it is not held within those 14 court days, the individual shall be released from county jail if they are in custody, and they shall be released pending the hearing. And the criminal case will be dismissed if and when the individual is accepted into care. So again, slightly different rules or parameters for FIST and IST, and it's important that we just reference those when we're dealing with one of these referrals. Let's talk a little bit about communication between courts. And this applies for the IST, the FIS, the AOTs, and the LPS referrals. So it's all of them. What this is allowed for, what the statute allows for is that if a person is referred by a court to care, there can be communication between the care court and the referring court. So for instance, a care court that is getting a referral from AOT, LPS, or IST can share case status information and relevant orders while the cases are pending in both courts. This is important so each of the courts know what the other is doing and what the status of those cases are, whether it's still open, whether there's been any dispositive orders made that would impact the other proceedings. So the statute does allow for that communication between the referring courts and the care courts. The statutes also allow for courts that are handling juvenile cases, whether it be dependency, delinquency, or transition cases. The juvenile court and the care court may communicate on case status and orders. Again, for the same reason, so that they each know what the other is doing and what the status of the cases are in each court and what orders, if any, have maybe been issued that are relevant to the other proceeding. The statutes allow for the parties to be aware of the communication between these courts, so they're aware of the content of it, but it's important to know that any case disposition discussions, any discussions or orders that are dispositive to the case must be on the record in the court in which the proceeding is being held. And that's just to assure that the official court record in each of the proceedings is complete going forward and that everybody has documentation of what dispositive actions have been taken. So that's communication between the courts, which is obviously extremely important when two courts are working on the same, working with the same individual. But it's also, and we're going to move to the next slide, it's also important that there be coordination outside of the specific communication we talked about. There needs to be coordination in services and supports and access to programs and a coordinated treatment plan. For instance, if the referral came from an AOT court and county behavioral health is becoming involved because of the care court involvement, it's important that the AOT treatment planning and the care treatment planning be coordinated to assure that there's no duplication and that the services are the most appropriate and the most coordinated. Equally important that the courts coordinate. The courts usually will be separate courts. The referring court and the care court will not be the same court, the same judge. So communication between the judicial officers or the courts is extremely important to assure that they're not conflicting orders or there are no delays in the processes. And most importantly, maybe early engagement. When there's other agencies involved, very important to early engage with the individual and with the agency to assure that there is continuity of what is being discussed with the individual, that they understand the different roles, they understand the different proceedings, and that the engagement is initiated to get the individual the services that they need as soon as possible, regardless of whether a care petition is actually ultimately filed or not. Great opportunity for early engagement of those individuals at that point. So I think that I've gotten through the nitty-gritty, and so I'm going to turn it over now and pull Deborah back in to talk a little bit about how courts and county behavioral health agencies could maybe effectively coordinate referrals and communicate around CARE Act when referrals are received.
Yeah, great question. Thank you. And clearly, with all of the details that you've shared from court to court, and that we've talked about from facility to county and facility to court, really there should be some best practices of county organizations working together and county behavioral health working with the courts. And so, a couple of examples that we've heard and some suggestions that we have. Is establishing protocols for the counties and courts to work together. Certainly, they can come together to create an agreement on their roles, expectations, timelines for referrals, protocols that they use for guidance and for feedback. Some courts are using a shared electronic system so that they can exchange information in a compliant manner, in a protected manner, and they're being able to use these systems to make referrals and to follow up so that nobody falls through the cracks. Thinking about regular stakeholder meetings, whether it's the DA, public defender, behavioral health, judges, and others, so that all of these logistics and processing of those details that you talked about can be done. A couple of other things that we've heard that have been really helpful is having a centralized point of contact so that there is the same liaison working from the county with the court so that there can be that knowledge, that information. It really does mean having like one expert there to help streamline the process and to work together collaboratively who understands how things are going to be happening. And then we would encourage that you leverage, or that the listener leverage all of the trainings and the resources that are out there, some that are on our website, but to help understand how they can work together. And so sharing those learning opportunities together and then processing them together, whether it's a tabletop exercise or a workflow that is being determined to ensure that both parties are able to collaborate. So lots of good stuff, Leela. Thank you for walking us through all the details. And I'm gonna take it over now with a little bit and just drive through what community partners and other referrals might look like. So as we talk about or we move away from some of those statutory referrals, again, those formal referrals, let's talk now about some of the non-statutory or the informal referrals. And in these cases, people or entities may make referrals to county behavioral health saying, I know of this individual who might benefit from care. Would you please consider this individual for a petition? And some of the reasons why that might happen is that the county BH may already be familiar with the individual. Perhaps that person has a treatment history within the county and it's a familiar face to either county BH or to the court system. In these cases, the county behavioral health agency might already have access to a person's medical records, be familiar with their background, and so some of that means that the process can be simplified and expedited. And while county behavioral health isn't required to take referrals from family members, they often do. And in this situation, we understand that it can be tension or stressful for a family member to petition around another family member. And with the county behavioral health stepping in and serving as a petitioner, it may be an opportunity to reduce some of the inherent tensions that might come through the filing of a care petition. So again, if a county behavioral health agency does accept those referrals, they can screen for eligibility before filing. They can be looking at existing medical records and content. They can initiate engagement pretty quickly. They can share information and equally as important, they could follow up with individuals who do not meet care criteria to offer additional services or other kinds of supports so that the person can continue to be seen for appropriate services in the community. So a couple of ways that they can consider these non-statutory referrals. We can talk about collaboration with other referral sources. As I mentioned, counties aren't required to do so, but there's nothing that precludes them from developing pathways of referrals for their system partners, like first responders, hospitals, providers. As the county behavioral health agency steps in as the petitioner, they can consider how those early referrals can be made to the county, who they can either step in and take over or again be the petitioner from the beginning. We've talked about some of those referral sources and, again, justice system. Maybe it's jail providers, county providers, doctors, psychologists, other first responders. And so this pathway, again, whether it's a referral to the county or the direct filing of a petition, if those relationships are established, these can be negotiated, and together they can come up with a plan for what may be the best petitioner to file. We have also heard that behavioral health agencies are partnering with jails and inpatient units regarding either the referral or a petition. And I think that especially if there are short or unknown length of stays, it may sometimes make sense for the county to be the petitioner so that they can continue to follow up with the individual after they are either released or discharged from a jail setting or hospital setting. So really considering what's the best way that the county can facilitate engagement, whether it's a referral, following up on that referral, or a petition filed directly. So a few opportunities in there. Since I mentioned justice system, let's go on to the next slide. And I do want to highlight, and here we are not only talking about jails, which I referenced earlier, but we are talking about various entities and organizations across a system, a justice system, and across a sequential intercept model of where people can be jumping in. And so there are a few points in the justice system where people can be identified or assessed for potential involvement in the care. Certainly, if there's a community contact during a crisis, whether it's a police, an EMT, a firefighter is responding, they may consider a petition or a referral to county BH. They may also consider it in educating family members who are on site or others who are present during this crisis, educating and providing information so that that family member or others could be considered making a petition or filing a petition or making a referral to the county behavioral health agency. Respondents' counsel can play a lead role in this, whether these are IST proceedings or an individual's attorney is supporting an individual to make a petition on their own behalf while they may be incarcerated or otherwise. And again, we just talked about that specific courts can refer to county BH or to care courts. And so during these court proceedings, care can be considered. Certainly while the person is in custody, during screenings, assessment or treatment processes, social workers, psychologists, doctors, and other healthcare staff can consider care. At reentry into the community, people may be connected to community mental health resources and to care so that things like housing and mental health services can be provided after release or upon reentry into the community. And then even as further on is under supervision. And so the idea for a probation officer to consider care and to either make a referral to county BH or again, we talked about filing a direct petition. So all of these system partners, it's an opportunity for county BH to work with them to create referral pathways and to establish a system that can make these pathways successful. So, Leila, one more pass back to you before we wrap up and before we give it to Patricia. Let's think about existing processes and relationships and what can be done to support these non-statutory referrals to care.
So, Deborah, you covered many of these earlier on an earlier slide, and I'm going to emphasize one that I think is extremely important that we've been hearing from a lot of the community and from various counties, that providing some mechanism for referral for families or loved ones or friends of individuals who may not have the ability to file a petition on their own. Either they might not qualify as a petitioner, or they don't have access to the same amount of information that might be necessary to file a successful petition. We really would encourage that county behavioral health consider a pathway for those type of referrals. Important, as you've pointed out earlier, to establish liaisons to work with system partners. Often one point of defined communication allows for system partners to easily make that connection and not have to spend too much time and effort trying to determine who they should be talking to about a referral. It just makes it smoother and easier for those system partners to be involved in referrals. And very important, the collaboration. Again, whether it's a collaboration with the community, whether it's a collaboration with shareholders, we've discussed collaborating with the courts, establishing processes and best practices and protocols to assure that everybody kind of knows what's happening and knows the best way to make the referral and get the referral processed. We know that some counties are actually establishing MOUs, memorandums of understanding between organizations so that the roles of everybody are clearly defined, and that when somebody else maybe comes into a position, they have a clear guidelines as to how they're supposed to proceed and how referrals are supposed to be processed, and that just makes it smoother and easier going down and into the future. So those are just some ideas that I think we've come up with and that we've seen in practice in the counties that seem to be working around referrals, both the statutory and the non-statutory referrals that we've discussed today. So with that, I'm kicking it back to you, I think, for the final time, Deborah.
Oh, actually, I think that we are going to be passing it to Patricia so that
Excellent.
she can take us off. Leela, it is good to see you as always. My pleasure.
You too.
Thank you. Patricia.
Thank you, Deborah and Leela. So as a reminder, the goal is that by the end of this session, participants will have a greater ability to do a few different things. Explain the difference between petitions and referrals, understand components of those referrals, identify differences in referral processes for those various system and community partners, such as those LPS designated facilities, some of those court referral pathways, and then describe how counties may process and respond to care referrals. So if you, there are a few resources for you to learn more about information. So we have a series of trainings on taking a trauma-informed approach, what that means and what that could look like, especially in a court-driven process for folks that have not been served well by the system and who may had negative interactions with the legal system, how to adapt the care process so that it recognizes their trauma and adapts. So we have a few of these resources, and in the training materials for this training, you can go ahead and click on those links. And speaking of the Resource Center, we have a number of resources, including a training and resource library, and several different toolkits, but there really is no wrong door. So if you have a question or you need to be connected to a resource, please go ahead and reach out to us at info@careact.org. Thanks, and let us know if you have any questions.